Call the meeting to order. This is the April 10, 2018 meeting of the Town Plan and Zoning Commission for the Town of Fairfield. First item on our agenda are the meeting minutes from March 27th, 2018. Does everybody have a copy of that? Motion to approve by Commissioner Corcoran. Second by Commissioner Noonan. I looked it over. I didn't see any corrections or edits. Does anyone else have any comments? All in favor signify by saying aye. Aye. Any opposed? Abstentions? Minutes are adopted unanimously. Next is 1152 Kings Highway Cutoff. Request of Attorney John Fallon for a 5-year extension of a special permit and site plan approval to April 8, 2023.
Mr. Chairman, this site is the vacant parcel that's easterly of and adjacent to the Stop and Shop parcel at the traffic circle at Kings Highway and Post Road. The Commission originally approved a one-story, 36,000 square foot retail building in 2006. The Commission in March of last year approved a change in use for that proposal from retail to medical office, utilizing the same site plan that was approved in 2006. The original special permit is expiring and the applicant seeks a 5-year extension to implement the project. Yesterday I sent some additional correspondence via email that further details the timeline of the events and why we believe that it still has yet to expire and is eligible for an extension. There was a letter you received requesting that you deny that extension or thereof have a hearing. I can go through that timeline if you need to, but other than that, we disagree with the folks that submitted the letter saying that they think it's already expired. And as I've outlined in the email that I sent, I'm happy to go through that should you want me to or have any questions.
I mean, personally, I think it would be helpful if you just gave a brief synopsis of that timeline and the
Sure.
the authority, the legal authority on which you base the conclusion.
Fine. The original application at the time it was approved, there was an appeal that was taken from that, and that appeal wasn't resolved until April 8th of 2009. So that starts the clock for the running time for the permit. So the effective date of the approval was April 8th of 2009. At that time, the statutes had a timeline of a 5-year time horizon with the possibility for 5 years of extension, although our regulations at the time said 2 years with 3 1-year extensions. But prior to that original expiration date, if you apply a 2-year expiration date to that effective date of April of 2009, that would be April 8th of 2011. Prior to that, in February of 2011, the Commission amended the regulations so we were in sync with the statute. We basically eliminated any reference to time and just simply, our regs now just say the timeline is whatever the state statutes say. And that effectively extended the approval to April 8th of 2014, which would have been 5 years from that original effective date. In May of 2011, the statute changed yet again. There was a couple of statutes that were changed in reference. There was during the recession, the legislature was concerned about approvals that have been granted throughout the state, but because of the downturn in the economy, you hadn't had a chance to develop. So they extended the time horizon for permits for 9 years from the original 5 years, which effectively extended this permit approval to April 8th of this year, with a possibility of 5 years of extension. So that is what this applicant is requesting. I think it's also important to note that the request to change the use that we heard, that this Commission heard last year wasn't just an administrative action. The Commission actually had a public hearing in February of 2017 and approved it on March the 7th, and we published that decision, and there was no appeal taken from that action at that time. So because of the evolution of our own regulations that kind of synced up with the state statutes, and the state statutes changing a couple of times in the lifespan of this permit. It's our opinion that the expiration date of the original approval would be April 8th of this year, subject to the request for an extension.
When were our regulations amended?
February 8th of 2011.
And initially, our regulations were what, 2 years?
2 years with the possibility of 3 one-year extensions.
And had, oh no, that was within the 2 years.
Yeah, the February 8th was within the first 2-year time period.
And when did the state amend to 9 years?
May 9th of 2011.
So up until this point, the applicant has not had to nor sought an extension.
That's correct. It just kind of got effectively extended riding along with the statutory timeframes.
Let's get a motion on the table so we can discuss and then we can ask further questions. Do you have a motion?
Move to approve.
Okay, motion to approve by Commissioner Noonan.
Second.
Second by Commissioner Levy. So, in February of 2011, and when our regulations were amended to reflect whatever time period was allowed by the state statute, what was the expiration of the time period?
At the time that that regulation adopted, the statute at that time was 5 years with a 5-year extension, so would have extended that initial approval to April 8th of 2014.
Right. Okay. And I mean, I suppose that when historically, when we amend a regulation that amends a deadline or a time period that operates with effect for any approvals or outstanding items, sort of retroactively for any that had been approved previously.
Yeah, that was the intent, and I think that was articulated in the purpose statement when that reg was adopted in February of 2011, because at the time we recognized that our regulation was out of sync with what the statute said, and we're also cognizant that it may again change, because it did shortly thereafter, so we didn't have to be in a position to update our regulations if and when the state changed the statute. If we just married it to the statutory time frame as it may change from time to time, we wouldn't then have to amend our regulations.
Right.
So I'll read it. That this was in the published purpose of that amendment. The purpose of this proposed amendment is to repeal language that is inconsistent with current statutory requirements, rather than adopt statute language as part of the regulations which may change from time to time. Reference is just simply made to the statute. So I think that was the intent of the commission, as the intent of the legislature was to extend the time horizon for permits that have been previously granted due to the downturn in the economy. And there is, it's only available for approvals that were approved, or applications approved before July 1st of 2011. So there's only a small subset of applications this will apply to. Anything approved after that date would go back to the 5 years plus 5-year extension.
Right. Okay. Does anyone have any other questions for Mr. Wendt? You want to say?
Quickly, based on comments from staff, the timeline presented, specifically the fact that our regulations were amended when the time, it was still outstanding time, it had not already been expired. And Mr. Wendt's statement that the commission had intended, and I believe that is accurate, the commission had intended to retroactively include applicants that still have outstanding timeframes. I would think that this still, what's the word? This still could have an extension for 5 years. It's still a pending and valid application.
Yeah, I mean, another way to say it without using the word retroactive, which I don't think it is a retroactive application, is that the amendment of the regulation extended the then current deadline on the permit. and so, having revised it, it was extended. So that's the way I read it too. Yep, Commissioner Levy.
It's similar to a statute of limitations or limitation of action, and generally when those are amended, unless they specifically say otherwise, they're considered procedural and applicable to any pending claims that might fall within it.
Yep. Okay. Anyone else? The motion on the table is to approve the extension request. All in favor signify by saying aye. Aye. Any opposed? Abstentions? Okay, the request is granted unanimously. Next is new applications for recommendation to public hearing. First is 1675 Post Road, zoning compliance application of 1675 Post Road Partners, LLC, pertaining to a 13-unit residential development pursuant to Section 830G of the Connecticut General Statutes, Center Design District.
This is an application you should be familiar with. It was denied a couple of months ago. There was a discussion about the occupancy of the first floor as proposed commercial. They've revised that to be a residential unit, so it's now a 13-unit versus a 12-unit. Same site plan, same basic architecture, but it's a revised application.
Okay, thank you.
Move to public hearing?
Motion to move to public hearing by Commissioner Noonan. Second by Commissioner Corcoran. Any questions or comments? All in favor signify by saying aye. Aye. Any opposed? Abstentions? Move to public hearing unanimously. Next is 175 Jefferson Street, special exception application of Sacred Heart University pertaining to 2 residence halls and a tennis pavilion in the R3 zone.
This, Mr. Chairman, is a continuing development of Sacred Heart of the former Jewish home property. You may recall they recently renovated one of the existing buildings to a residence hall, and during that presentation they showed some future footprints. These are two new residence halls that they're looking to build, which does require a public hearing.
Okay, thank you.
Move to public hearing?
Motion to move to public hearing by Commissioner Noonan. Second by Commissioner Corcoran. Any questions? All in favor signify by saying aye. Aye. Any opposed? Abstentions? Move to public hearing unanimously. Next is 3685 Blackrock Turnpike, special exception application, Blackrock Congregational Church for a second floor addition in the R3 zone.
I don't have anything other than what that description says, only to say that when this church facility was originally approved, it was larger than on plan than what they ultimately built. They scaled back the size of what was ultimately built, and they are now going back to apply for a second floor addition, which is ultimately modestly smaller than the original approval, but they didn't have all the money to build it at once, so they're now coming back for a second phase, if you will, second floor addition.
Okay, great, thank you.
Move to public hearing?
Motion by Commissioner Noonan, second by Commissioner Corcoran. Any comments? All in favor signify by saying aye. Aye. Any opposed? Abstentions? Move to public hearing unanimously. Next is old business. 220, sorry? Oh, no, I didn't actually. Thank you very much. Commissioner Noonan just reminded me that we have a few commissioners absent, and we have our alternates that are filling in. All 7 commissioners are voting and participating in all matters tonight. We have Commissioner Gordon sitting in for Commissioner Francis, and Commissioner DiGiacomo sitting in for Commissioner McAleese. And it hasn't, I haven't had to take a roll yet because we've been all unanimous on everything, so that's a good thing. So old business is 226 Old Post Road, zoning compliance application of Equinox Fitness Club for a monument sign in the Design Industrial District.
Okay, you were all here for the public hearing at our last meeting. This is an application for a monument sign for Equinox. As I think we talked about at the hearing, the wall sign package is going to be handled administratively because that's going to be kind of a swap out of what they had before. The monument sign meets the size and design criteria of a sign for the design industrial district with the exception setback from the street. They're looking to gain approval for a lesser setback, almost to zero, basically, from 25 feet. And that is in your discretion pursuant to section 29.8.1, allows you to consider a lesser distance, but requires a 2/3 vote of the commission or 5 votes to do so.
Okay. Thank you. Commissioner Levy?
I'd like to make a motion to approve a reduction of the street setback for the monument sign as per the plan on file.
Motion to approve by Commissioner Levy. Second by Commissioner Noonan. Commissioner Levy, you want to start?
Yeah, I think, I mean, in this particular site, the building is set back, and a monument sign 25 feet off the street would be hidden by the gray goose, which is right there. We're not an architectural review board. It meets our requirements in terms of the design and shape of the sign. The opposition seemed to be to the, the appearance of the sign, and yet the two that were presented in evidence of other Equinox signs were right on the street line. Similarly, I note that Artisan in the area has a sign right on the street line. And at this particular site, there's a crosswalk right where the monument sign would be. And I think that this will help alert drivers that there is likely to be, people coming to the site. It'll draw their attention to the potential for pedestrian traffic. And I think it would be appropriate to allow this to be at the street line rather than set back in the parking lot where it wouldn't be seen. It is consistent also with the appearance of the building right there, and we are not in the historical district. So based on that, I would think it appropriate to allow this by 2/3 vote for a reduction in the setback.
Commissioner Noonan?
If you have something, Joe, go right ahead.
No, I do have comments, but you seconded. Feel free.
I left my notes at work, so excuse me. The main opposition that I understood was that it's just the architecture of the sign and the design of the sign didn't meet the neighborhood. The issue I had with that was we approved a building with that type of design and architecture. I just found it very somewhat contradictory, particularly from the applicant's view, to be allowed to build the building as they've had and as we approved, and then not have a similar sign to it. I do believe it would be impractical that the sign be in the parking lot. My main concern was whether, for safety, whether there were sightline issues. I don't believe there was any testimony to that. From what I can gather from looking at the plans and going to the area, I don't believe that would be an issue, particularly crosswalk being there and the speeds being, what, I think they're 25 miles an hour. 25 miles an hour, but I'm happy to hear the rest of my colleagues and their views.
Thank you. Commissioner Meyer.
I did hear the opposition testimony. I looked at all of the pictures that were taken, the renderings from the applicant and the pictures from the opposing members of the public. I don't see that the proposed sign is out of character with the building. I don't think it's too big or too shiny, so I believe it should be allowed with the setback east exception.
Commissioner Corcoran.
I agree with the neighbors that the sign is out of character with the other signs on the street. And I don't believe they need a sign out on the street because the building is quite visible. It's large. It's not on a busy street where someone would miss it. Or if they did, it would be very easy to turn around and go back, but I don't think they would miss it in the first place. Since it doesn't meet the regulations, I don't think I approve this. We also have a picture submitted of another sign that would be more appropriate for another equinox, but I think that's irrelevant. I think this sign just isn't appropriate for the neighborhood, and since it doesn't meet the setback, I would vote against it.
Okay, thank you. Anyone else? I have some comments. Yeah, I agree with you, Commissioner Corcoran. I'm actually surprised that those who preceded me were all supportive of it. Yeah, it's not a sign as of right. We have regulations for a reason. There's no need for this monument sign, it's particularly the way that it's been proposed. We didn't have design authority over the building. It complied with our regulations. They actually didn't remove all of the buildings so that they could grandfather certain of the nonconformities so that they could build the building that they wanted. We now have the opportunity actually to say something about the sign because it doesn't conform with our regulations, and they need our discretion to grant a waiver of the setback. That all having been said, they do not need a sign this big, this close to the street to find this building. It's unnecessary. So I would urge at least one more of you to come back over onto the other side of the fence here, because it needs to pass by a supermajority. We need we need 5 out of the 7 of us to approve this. All they need, if anything, is a small marker. If you're worried about somebody driving down this street looking for a number, if they can't see this building for some reason, and they're looking for a number on the street, a small number marker. I might be inclined to waive the setback requirement if they were willing and interested to propose some sort of marker that would be more appropriate in keeping with the scale of the streetscape and the neighborhood sort of feel of this, rather than making it more industrial the way this, I think the way that this sign would, would make it. So,
I would add too that I agree it's not necessary because it's not the kind of place that you're driving by and you're like, oh, let me go stop in the Equinox. Like usually you plan to go there, and so you know where you're going to some extent in the GPS and everything like that.
That's an excellent point as well. This is not a, they're not looking for pedestrian traffic, just kind of, oh yeah, I'll pick up some milk on the way home and there's a Cumberland Farms. Like you're going to Equinox. You know where it is. So, that's my feeling. Anyone else have any thoughts? No? Okay. Well, the motion on the table is to approve, so a vote in the affirmative here passes this. We need 5 votes to make it go. So, all in favor signify by saying aye.
Aye.
We have 3, Commissioner Meyer, Noonan, and Levy. All against? Nay?
Nay.
Yeah. And we have Commissioner Gordon, Wagner, Corcoran, and DiGiacomo against. So the item fails. Next is 1865 Blackrock Turnpike, special permit application of Katona Corners LLC pertaining to an addition to an existing building in the Design Commercial District.
Okay, once again, everyone was here at the last hearing. This is an application for Billy's Bakery seeking to enclose an existing patio with a greenhouse enclosure to provide 320 square feet of patron space. This matter was reviewed and approved by the Zoning Board of Appeals with regard to a reduction in the street line setback from Katona Drive, as well as for parking for that additional patron space. The considerations for a special permit are found in section 25.7.7. Is the development shown on the site and architectural plans of such character as to harmonize with the neighborhood, to accomplish a transition in character between areas of unlike character, to protect property values in the neighborhood, to preserve and enhance the appearance and beauty of the community, and to avoid undue traffic congestion? That is what I have, Mr. Chairman.
Okay. Thank you very much. motion?
I move to approve.
Motion to approve by Commissioner Corcoran. Yeah, were you on? Second by Commissioner Noonan.
Um, This application agrees with our regulations. I don't see any problem with it. I think it's a good addition to the neighborhood.
Okay. Commissioner Noonan?
I agree, I thought it was a good application. I thought it met the standards we need to show in the special exception. No undue traffic.
Oh, sorry.
Excuse me. No undue traffic, no effective property values. If anything, it just seems to be using a similar, it's just enhancing a use that's been, they've been using for some time now for the benefit of their customers. So that was a good application.
Anyone else? I agree with the comments that have been made. Are we ready to vote? Motion is to approve. All in favor signify by saying aye. Aye. Any opposed? Abstentions? Okay, the application is approved unanimously. Next is 3C, zoning regulation amendment. Application of Post Road Residential LLC to amend section 10.18.3 of the zoning regulations. Do you want to talk about both of them
Yeah,
together? All right, so I'll call 3D as well. It's a companion. 333 Umpqua Road, special permit and request for determination as a transit-oriented downtown district. Application of Post Road Partners LLC for a 90-unit residential development.
Okay, thank you, Mr. Chairman. The first facet of this application, as you just read, is a proposal that seeks to amend the transit-oriented downtown district regulations that were approved by this commission in September of last year. Those regulations, as those of you who were here certainly will recall, and those of you who were not, they were not adopted as originally proposed by the applicant. Among the changes that were made to the proposal when they were adopted was a requirement that the building mass had to be divided into more than one building, provided that no single building shall be less than 40% nor greater than 60% of the total floor area of all buildings exclusive of structured parking. The commission also imposed a total unit cap of 90 units. The original application had called for 118 units. Therefore, even though that the regulations were revised and adopted, the special permit for the original plan was denied. So the applicant has returned with a revised application with a reduction in the unit count to 90 in accordance with those adopted regulations, split into two component buildings. The applicant, however, is seeking to amend the regulations to permit a ground story connection for an amenity area or corridor that is common amenity or lobby service area to serve both buildings. You heard about that design consideration during the course of the hearing. And according to the applicant, the applicant is proposing to maintain a separation of the larger masses of the building and a proposed connection at the ground floor level, which would not be visible from the street and would have limited visual impact from other vantage points. The consideration for the regulation amendment are similar to that for zone change. Is the proposal consistent with the plan of conservation and development? Does time and experience in responsible planning for contemporary future conditions reasonably indicate the need for the proposed regulation amendment? Has it been demonstrated that that proposal is warranted and would serve the general health, welfare, and safety of the town? And does the proposed amendment promote a level of development that would serve to protect property values in the neighborhood and enhance the community? Would the proposed amendment permit a level of development that would increase undue traffic congestion? The next piece of this is similar to what was done in the Commerce Drive area. Application is a request to designate this as a transit-oriented downtown district. As noted in section 10.18.1, the purpose of the transit-oriented downtown district within the Design Residence District is to enable the development of a transit-supportive neighborhood within walking distance of commuter rail transit in the downtown portion of the Post Road of a scale and design that is appropriate to the existing neighborhood, context, and to the character of the town. And lastly, you have the special permit component, which is for the 90-unit residential development. The proposal includes 1 studio unit, 21 one-bedroom units, and 68 two-bedroom units. totaling 157 bedrooms with 170 parking spaces, 128 of which are in a covered garage and 42 surface spaces. The considerations for a special permit you just heard in the last section is the development shown on the site and architectural plan of such character as to harmonize with the neighborhood, to accomplish a transition in character between areas of unlike character, and to protect property values in the neighborhood, to preserve and enhance the appearance and beauty of the community, and to avoid undue traffic congestion. So you've got two things to consider here. The first would be the regulation amendment with respect to the proposed connection of the two main parts of the building, and the second being the authorization to have this determined to be a transit-oriented downtown district with the companion special permit application. I'd be happy to answer any questions if you have any.
Thanks. Do you have a summary of the conditions that were we
The
talked about?
conditions were mainly with respect to the affordability plan.
Yep.
The applicant agreed to revise the plan in accordance with the model plan of the Affordable Housing Committee and identify the actual units that they were going to set aside as the 9 affordable units.
Right.
Beyond that, I don't have anything beyond normal standard conditions.
I was trying to remember that the applicant had conceded with respect to the affordability plan, but it was to revise it.
They agreed
adopt the
to
model.
revise, right, there was agreement on, with respect to revising the affordability plan. They did not agree to increase the percentage of set-aside units beyond 10%.
Right, okay, very good, very good. Yeah, so I think that we ought to consider these separately. I mean, I think we should take up the regulation amendment first. It's on that basis then that we would consider the special permit. Commissioner Levy?
Yes, I would move to approve the amendment to 10.18.3 as per the proposed amendment.
Motion to approve by Commissioner Levy. This is for item 3C, zoning regulation amendment. Okay, second by Commissioner Noonan. Okay. Commissioner Levy?
Yes, I mean, as I see it, the proposal or the proposed amendment is to allow the two buildings to be connected in some fashion, basically along a ground floor with a purpose of traveling between buildings and perhaps providing amenity services. What I found compelling was the testimony from residents at the Autobahn residence or apartments that are right nearby, and how they wish that they similarly had their buildings connected so they could go from one to the other. I think in this particular case, the plan itself, clearly there's a demarcation between the buildings. The intention is to allow a connection as opposed to bypassing the regulation that there be two separate distinct buildings. A monolithic structure connecting the two would not be permissible under this regulation as amended. I think back to my college days when we used to have to go down to the steam tunnels to get from one place to another. I think in a New England climate to allow a connection between buildings is appropriate, particularly here where certain amenities might be in one building and not the other. So on that basis, I think this amendment would serve the purposes, you know, as far as the zone change here, it would be consistent with the regulations as adopted and, in fact, improve them, I think.
Thank you. Commissioner Noonan?
Thank you, Chairman. This was somewhat difficult, particularly because when we had this initial application last year at some point, this was a very contentious hearing for the commission, and we battled with what to do with this, with the first application. And we settled on this idea that there would be two separate buildings to break up what could be just a very big building. I note the applicant is correct that it did not have a say in those discussions. This was during our executive session. We had made amendments, and they didn't necessarily have a seat at the table when we were going through this. And their point is fair that when you put pen to paper, things come up and things are different. What I would suggest, though, is that we not take the proposed amendment word for word, but instead that we would have the following language only: except said buildings may be connected by a corridor on the ground floor for the purpose of traveling between buildings, essentially taking out the amenity area. For me, at least, I think that will better serve the commission's intention of keeping at least the buildings that look separated. Now, they will be connected by corridors, and the corridors may be a few feet or 2 feet or however long it is. But I think that's a fair condition that will force at least this applicant or even similar situated applicants to break up the building, so to speak. Not have it so 2 buildings are connected by an amenity space, which could be, while they limit it to the ground floor, could still be, you know, a pretty sizable addition. It could still be something that connects the 2 buildings a little more in size than I think the commission, at least we intended back when we wanted the 2 separate buildings. I mean, to be fair, when I asked the applicants, could you get to one building or the other without going outside, the answer was yes. And I raised concerns that they had put forth an application that almost seemed like they wanted us to follow them down the route of approving this amendment. I accept the architecture's explanation that this is, you know, having that central building for entry and amenities was preferable. I think it would be a more attractive building if it was connected by a corridor between the building with the central building, the one building on the left, the smaller little portion in the middle, and just to have one laying out there would be odd. So considering what the commission had intended, again, 2 separate buildings, that the applicant didn't have a seat at the table at those discussions, that they do put forth a fairly reasonable and fairly minor, well, let's just say at least reasonable request. I do believe that I would support it with the amendment that I'm suggesting, that at least the amenity language be removed. In this respect, I think it would, you know, again, we just made this this regulation a few months ago, but I do believe it would protect property values. I think with a more of a, what's the word, a more suitable building, connected complex, as opposed to, again, just a building, a small portion in the middle, and an unconnected building on the right. And I think it would serve general health and welfare and the safety of the town. Again, it's a minor, well, it's a fairly relatively small request considering the entire TODD. The fact that we just made this a regulation a few months ago, I'm in support of it, though I would request that the amendment that I said, and I'm happy to repeat it if needed.
If I may, am I correct that you're simply suggesting that the words "or amenity area" be deleted?
That deleted, and the phrase "or providing amenities servicing both buildings."
Okay.
That would be my request. That would be my, if I was the first one, that would have been what I would have proposed.
Well, yeah, I think what you're asking is whether Commissioner Levy would accept an amendment to his motion.
I might, but I have a question as it applies. I mean, in this particular set of plans, as I understand it, the amenities are in one of the buildings. The connection is basically a 10-foot area between them. So I'm not quite sure how,
Well, as I understand from the applicant, this is what Chairman and I, well, at least the Chairman spearheaded and I followed suit. The application is, the buildings are connected by corridors. There's you got a big building on the left, big building on the right, smaller amenity entrance building in the middle, connected by 2 corridors. So I don't believe my request is going to affect their design. I'm just asking that for any future applications, that by taking out this amenity language that was provided or proposed, it would further, at least it would be a compromise that would further the commission's initial intent to break up the building's size. So I don't think that my suggestion affects this application, because I think the applicant's attorney was clear that this was connected by corridors. Small corridors, mind you, but corridors nonetheless.
Yeah, no, I would agree with that, but, and I'll be right back to you. So Commissioner Levy, did that answer your question? And Mr. Went, you looked like you wanted.
No,
had something to
I had
say
the
there.
same, really the same question. So
Okay.
as if, just for the sake of argument, should the amendment be amended, as you suggest, in your opinion, the site plan proposed by the applicant would still comply?
I believe so.
Okay.
Okay, so, Commissioner Levy, does that satisfy your question? Okay. Commissioner Corcoran, do you want to chime in now, or do you want to wait until the motion's been amended?
Go ahead and amend.
Commissioner Levy, you want to amend the motion to
Yeah, I would
incorporate
amend
those
the
changes?
motion to remove the reference to amenity or providing amenities servicing both buildings.
Okay, very good. Commissioner Noonan?
Second.
Yep, okay. So the motion's now been amended to remove that language from the regulation. Commissioner Corcoran?
I have a question and a comment. Mr. Wayne, does this amendment apply to any other property except maybe the parking lot at,
What other, can you just, so
Well,
during the
the-
course of the hearing,
The question,
first
as I
hearing.
understand it, is what other properties beside this subject property could
Right.
possibly be subject to a transit-oriented downtown district? Is that your question? It has to be a 3-acre parcel as of that adoption date, and be, so I think there's really 2 other parcels, unless it's amended, would be the town's parcel and, well, a second town parcel, which is Tomlinson Middle
Right.
School. But both would need to be, neither of them are presently in the design residence district. So, snapshot view, this is the only parcel, subject to a future zone change to design residence district for either of those parcels. This would be the only
Right.
parcel.
okay. My comment is that, both the original amendment, as the applicant pointed out, that you could build 2 buildings adjacent to each other and meet the regulation, so that's weakly worded, but it only applies apparently to this one property. And this amendment that we're talking about now, again, I think is also weakly worded, and I don't have an improved wording. But the issue, I mean, once this is built the way we envision it, which is the connection? I mean, you've got, we allow a
they're
connection, and we're
both.
gonna have 2, that you can't tell which one is which.
I mean, I think that, and that's a fair point, and I think that they're both the connection, and that is what would satisfy this, is that they may be connected by a corridor, and then you would have on the left side, you would have a corridor connecting the first building to that space, and then the second building with a corridor connecting it to that space. Now, in that sense, would that be 60/40? I mean, no, I don't think it's the third. I think, so fine, you've got the building on the left that's got the amenity area, the building on the right, and then the small corridor that connects that to that.
I think once it's built, it's gonna be hard to tell what happened. Also, we don't have any, didn't we talk about there's no restriction on the height of this?
No.
It says it's 1 story.
On the ground floor.
On the ground floor. So, that's a fair comment too. I mean, you know, the corridor could be, 2 stories tall, even
Well,
though
the
it's on the ground floor?
Yeah,
Yeah.
just as the amenity building is.
Mhm.
But again, it only seems to apply to this property. I just think it's loosely worded. Looks
Yeah.
like it won't get us into trouble.
Well, I mean, frankly, well, it was, as was pointed out, a firewall could technically make a distinction between 2 buildings, such that a corridor might not even be necessary, which of course was not our intention.
No, but I think the comments I'm hearing is, I think, if I'm not to speak for the commission certainly, but it sounds like you're generally supportive of the plan that they put forth. Regardless of how this gets wordsmithed, it's up to you as to how that regulation applies. You have to approve it as a transit-oriented downtown district in the next phase of this. So you're right, it has very limited applicability in the discretion to make that overlay rests with this commission. So I would go back to whether you think this particular plan meets the intent. There's a substantial separation between the main structures of the building, and if you think it makes sense to connect them, then I think what you're discussing makes sense.
I have a question.
Yeah.
So you're saying like it wouldn't change, but that connection is it is an amenity.
That's not, and so the distinction being made, that the applicant was arguing, is that the building on the left
Right. That this is
consists of the
included
residential area
in the building on the left.
and the amenity pavilion,
I see.
and the building on the right is 40% and is not physically connected on the ground floor
Right.
by a corridor. Commissioner Noonan points out that you can get into the amenity area by going downstairs through the parking garage and then coming back up into the building on the left.
Right.
So as a practical matter, it's not, you can still move from one building to the other without going outdoors, but perhaps that's not convenient because the parking garage isn't heated.
But you're talking about this space right here, right?
That little space right there, connecting the buildings.
But that's not going to change the look of it being one building or two buildings.
Well, you're making the applicant's argument right now, that it doesn't have an impact on the visual from the street, that
But
it won't.
if they moved the amenity so that this was all a space, then it would be two buildings.
Say that question
If they
again?
took the amenity off and put it somewhere else, it would make it two buildings.
That's correct. The applicant has said that they don't want to have a separate building with amenities, and they don't want to have duplicate amenities
Right.
in each building. Want to have one post, one
Mhm.
gym, one, whatever. I mean, the good news is that apparently our efforts from 2017 made them go back to the drawing board and regroup with the neighbors and tweak their plan, which resulted in, from what we heard, and what we've seen, I think, is a better plan, and it's more attractive and everyone supports it. We heard, I don't know, did anyone hear any opposition to this revised proposal? Well, the affordable housing component, right? So the criticism that we heard was that it merely complies with our regulations regarding the number of affordable units, and that we should be requiring more affordable units, which, is it's a fair criticism, but that aspect of our regulation was not proposed to be changed, and it wasn't changed, and it complies
I meant
with that.
more in jest, but
Yeah.
To answer your question directly, no, nobody was against it.
Yeah, no, but that was a point of criticism there, but with respect to the overall proposal, I think he's supportive of that. I'm frustrated, and just to, perhaps my disposition gave that away, because it was not my intention that there be two buildings that might be within 2 feet of each other, and that it was my intention that they be separated, and I guess we needed to include freestanding and the specific number of feet that I wanted there to be in between the buildings when we were talking about this in 2017. But that having been said, I think it is a much more attractive proposal. It's you know, it's fewer number of units. I think we got substantial improvement to what we were presented with previously. So, I mean, I think that's a good thing. Good. Commissioner Noonan?
I think to the extent necessary, I think the language actually protects against having just a firewall.
Well, I think I think your point is that given the additional language, it could be said that the regulation implies that the buildings are freestanding because they may be connected, although it says may be. If they, so I think the alternative would be if they are freestanding, then they may be connected, but they
Yeah,
don't need to be, you know.
And my only suggestion is if you're concerned that the corridor somehow can be 2 or 3 stories, is to put a one-story corridor
So ground floor,
Or-
on the ground floor,
by a one-story corridor on the ground floor,
by a corridor on the ground floor of no more than 1 story.
whichever. I mean, it's obviously not part of the plan now. I don't think it would be envisioned. I think it probably would contradict,
Yeah,
certainly the spirit, probably
What?
the word of it,
I
but
would
of
object to that amendment,
course,
You know,
limiting it to 1 floor.
what, okay.
corridor?
Yeah.
But why is that?
Well, you might want to have an atrium ceiling for artistic purposes. You know, I mean, it's on the ground floor. It's a connection. And also, there may be people, you know, there's also a reference to you can still go down to the garage area and get there. Well, there may be people who are disabled, and be much easier.
Handicap accessible, there's an elevator.
Yeah, this may be an easier way to get from one to the other.
But why?
There won't be an
why have a
elevator
height-
going across,
But what's your contention with a height restriction of 1 story?
because it may well be that artistically 1.5 stories would look better. I mean, that's something, I don't see where the height of the connection is of any significance. The purpose is that it be a connector,
Well, the purpose,
whether it's 10 feet or 20 feet.
well, like we've gone through, the spirit was to have 2 freestanding buildings.
Mhm.
1-story ground floor corridor splits that up, so to speak. So you're not having 3 stories to go to the extreme, where now really you just have one big building with, you know, very narrow bottleneck down the line. Want to put 1.5 stories or something like that, that's fine, but I think the idea is to limit it so it doesn't have usable space above it.
I agree. Anyone else?
I have a question. Obviously, the commission last year had some issue with the proposal, and I wasn't on the commission at the time. I'd like to know what the difference in square footage from then first to second proposal, and the difference in the number of beds.
Mr. White, or Mr. White?
I had that,
It was handed.
I have that
was handed
information,
out.
I'm not sure I have it with me. The bedroom count is similar. What's changed is the unit count. They've increased the number of 2-bedroom units as a result of the change. The square footage is reduced, and I have, I don't know if I have that in here.
I don't know, you did include in our packets a 1-pager at the last meeting.
Yeah, I know. I know I didn't get it.
You know, the alternative
It's-
here.
It's substantially smaller. Oh, here we go. Do we have this combined? I don't have the number. I had it in the packet from the last time. I don't have it with me. It's smaller.
Okay.
It's by about 30,000 feet, I want to say, off the top of my head. But
Okay.
I had prepared that comparison in a previous document. I just don't have it in front of me.
So it was 118 units, mostly 1-bedrooms.
It was 119 units with a higher percentage of 1-bedroom units in the previous proposal. So the bedroom count, the density permitted is 50 bedrooms per acre, which this complies with. And what the commission did as part of the discussion and adopting it last time was we just put a hard unit cap at 90, but left the 50 bedroom per acre density permitted. The other thing I'll say, again, I know you're debating the one-story limitation potential. I just want to go back to what I said before, because of emphasized by what Commissioner Corker indicated. There's very limited applicability to this as it's this TOD reg as it was adopted. So I would go back to, if you think, if you like the plan as it's presented, then I think what your proposed amendment that's on the table accomplishes that. The only other thing I'll say is, you may know, and we discussed this, is we're going to be embarking on a TOD study with a consultant as part of our POCD update. We've just chosen and engaged the consultant for that purpose, so we can get into a more finer discussion of potential broader applicability of such an amendment should this commission want to do so, and at that point can flesh out in great detail certain design criteria that may not have been part of this original consideration.
Yeah.
So as it's presently constituted, it's limited applicability.
So is in the plan that's been proposed now, the corridor that they're talking about is one story?
That's correct.
Mm-hmm.
So we don't need the amendment.
No, I think it's just the opposite. I think we should put the amendment in and include that it be no more than one story, because that is keeping more to the intent of the commission when we passed the amended regulation in last fall, to
Yep.
provide for more than one building, and that it
Right.
should be a corridor that is of no more than one story, and I think that's part of the reason why the applicant also proposed it this way.
Yeah, it
And-
would, the plan before you would comply
Right.
with that. In either case, you could have a higher architectural element as your main entry, as they do here, but it's just the connector piece has to be limited to one story. So the overall entryway wouldn't be limited necessarily to one story, but where it connects would be, as it would comply, the plan before you would comply, even if limited to one story.
So we need a new proposal.
Well, no, the proposal's still there. Commissioner Levy?
I mean, perhaps, I mean, it's largely semantic, particularly as it applies here. But, I mean, when you're talking about a connection that is on the ground floor, only for purposes of connection, presumably you're not going to have a second floor.
Then say it.
But you might want a more open, architectural appearance there. I don't know. I could say not to exceed 2 floors in height,
Yeah,
with
but
the understanding that
I'm
it
not
be an
voting for it.
open corridor.
Well, again, the only thing I would suggest is limiting it to one story would not change the plan before you, in my opinion. And we're going to embark on a broader discussion about potential broader applicability for other parcels, if there's an appetite to do so through our consultant, in which case we can
So you're
get
saying
into
is
those more.
we could limit it to 1 story and revisit it later.
Yes.
In that case, we can limit it to 1 story. I'll make that amendment.
Okay. So the amendment has been amended. Commissioner Noonan, you accept that?
Yeah, so it'll read, on the ground floor of no more than 1 story,
Correct.
for the purpose of, yes, I accept.
Okay, so the amendment is now, quote, "Except said buildings may be connected by a corridor on the ground floor of no more than 1 story for the purpose of traveling between buildings." Okay,
Correct.
all right. Does anyone else have any other comments? Okay. All those in favor signify by saying aye. Aye. Any opposed? Abstentions? The amendment is passed as amended unanimously. So the next thing we need to consider is the special permit application.
Yes, you need, basically, there would be a special permit motion along with the finding with respect to the property qualifying as a TODD district.
Right, so the motion should be that it qualifies as a TODD and to approve the special permit, or do we need to do it in 2 steps?
No, I think you do it in one, as you just said.
Okay.
So moved.
Motion by Commissioner Corcoran, second
Well
by
played, Mrs.
Commissioner
Bennett.
Noonan. Second by Noonan. No, that's okay. You're not doing so well tonight.
Getting over something.
It's that vanilla cherry Coke you got there.
Zesty blood orange.
All right, so does anyone have any comments? No, now that we've approved this regulation amendment, the plan complies with our regulations, and for all the reasons in the staff report, we should approve this.
Yeah, kudos to the applicant for coming back with a good application. Certainly, to me, when I go through the consideration of special permit, meets them, harmonizes with the area, protects property values, good for no undue traffic based on the traffic report received. It's a good application.
Okay. All in favor signify by saying aye. Aye, yep.
Oh,
Yes,
What do we
Mr. Wen.
understanding we're in folding in those affordable housing conditions as we previously discussed?
Yes, forgive me, yeah, so I meant to do that.
Okay.
So, Commissioner Corcoran, your motion is to designate the application as a transit-oriented downtown district and to approve the special permit application with the conditions that the applicant provide for an affordable housing plan that is consistent with our model plan and identify specifically the individual units
Correct.
that will be designated affordable.
Yes.
Commissioner Corcoran, Commissioner Noonan?
yes.
Yes, all right. Okay, thank you, Mr. Wen. So with that, all in favor signify by saying aye.
Aye.
Any opposed? Abstentions? The special permit and TODD is passed unanimously.
And Wes, you-
Bless you. You just had to punctuate that one, didn't you? All right. Next is our public hearing, 571 Bronson Road, re-subdivision application of the estate of Georgia Boria for a re-subdivision of 2 lots in an A zone.
Mr. Chairman, members of the commission, for the record, my name is Bill Fitzpatrick. I'm an attorney in Fairfield with the law firm of Fitzpatrick, Frame, Bologna. We have offices at 1735 Post Road. I'm here this evening representing the applicant, the estate of Georgia Boria, the owner of the property located at 571 Bronson Road. The Boria family has owned this property for approximately 61 years. Property presently contains a single-family residence on the south and a barn on the north. Property is located on the westerly side of Bronson Road. This property is located in the Residence A zone, which requires a minimum lot area of 9,375 square feet. The parcel contains 19,623 square feet. The proposal here is to subdivide the property, retaining the existing single-family home and creating a new conforming building lot to the north. The new proposed lot, Lot 2, will contain 9,381 square feet in conformance with the minimum lot area requirement. The lot containing the existing single-family home will contain 9,519 square feet of net floor area, excuse me, net floor area, which again conforms to the Residence A zoning district. Both lots conform in all respects, to our knowledge, with the applicable zoning regulations, including, as I have stated, lot area as well as the square. At this point, Mr. Chairman, I'd like to introduce Mr. Michael Paterla, a professional engineer with the Huntington Company who prepared the plans, and he will describe them for the benefit of the commission. Michael.
Mr. Chairman, members of the commission, as Bill said, my name is Michael Paterla, licensed land surveyor, licensed professional engineer, member of the Huntington Company, and our office is here in Fairfield. As Bill said, the proposal is to get 2 lots. The existing house is serviced by public water, public sewer. The proposed house will also be serviced by both. We had a soil scientist on the property. There are no wetlands, but we are in a regulated area, and we were before the Conservation Commission late last year and got their approval. Part of my package that was submitted included a set of drainage computations and also a set of sightline computations. They were reviewed by the engineering department here in town, and there'll be no increase in stormwater runoff for all the storms, including the 2, 10, 25, 50, and 100-year storms. And also, there's a sightline. The posted speed limit on the street is 25 miles an hour. The existing driveway meets the sightline requirements for that, and I also checked the 40-mile-an-hour speed limit, and it also checks for that also.
Mr. Paterla?
Yes.
Why are we using the shared driveway here?
It was, when we checked a proposed driveway in lot number 2, I couldn't get a sight line for the driveway of more than the posted 25-mile-an-hour limit. And it was our thought that if we came in and said we meet the 25-mile-an-hour speed limit, most people would say, who drives 25 miles an hour anymore?
Well, yeah, that's
And
right. The
we're not
calculation is
policemen, but it's
we should be basing it upon the, I think it's 85% of the measured speed, right?
Yep.
Which you weren't able to get to a sight line from the other
Not on this. As I say, it checks for 40 miles an hour on the existing driveway.
Yeah. Okay. Okay, thank you. Where's the calculation?
Mr. Chairman, the legal test for the commission's evaluation of a subdivision application is as follows. The
Before you
town-
summarize,
Yes,
are the calculations for the sight lines? I didn't,
there's a, like a 6-page, 11 by 17 submission.
11 by 17. You see it?
Here's 17.
It should look like this, Mr. Chairman.
I don't see that. Sorry. Did I see that?
Good.
Yeah, I don't recall seeing this in our packet. No. Yeah, okay. So, did you have another copy of this?
I have one more that I submitted. I'm just looking more now.
You have one. Mr. Paterla has one as well.
I could submit this to Mr. Wentz, and
I have one record copy.
I'll handle it on this end of the table.
Yeah, why don't you, all right, let's do that. All right. Okay, very good. So he's gonna scan it and put it in here. So can you just,
I'll go through it.
yeah, thanks.
Go ahead.
So, Mr. Paterla prepared this, but if I can take you through it. The stopping sight distance for 25 miles an hour, based on the chart here, is 156 square feet. That takes into account downgrades, upgrades,
All right,
so it's 156 square feet.
both north and south,
Correct.
okay?
Correct. Right, Michael? The topo map on the next page shows that 156 is satisfied.
Yeah,
Then, Mr. Paterla did an analysis. I can't tell you what these two graphs are. Actually, Michael, take over on this.
Then the next two sheets are profiles that show the sight line that's required for 25 miles an hour. The page after that is the state requirement for 40 mile an hour speed, and that's requires 306 feet.
yeah.
And again, the next couple of sheets is a topo sheet and the profiles. Unfortunately, I don't know why P&Z didn't get these, but as I said just before, I did review both the drainage computations and the sightline computations with, of course, Laura Pooley in our engineering department, and she had no problem with either one.
Right, okay, good. So that all looks good there on the, for the driveway. So when do you, deal with the easement?
You deduct net floor area. That easement is deducted from the lot area of the existing home lot, and it shows 10,242 is the full lot area.
Yeah,
9519 is the net lot area after the easement's deducted. So it's been deducted
I see.
in the zoning chart.
And then you'll just, file that as part of the subdivision on the land record?
Yes,
So that it runs
and
with
quite
the
frankly,
lot?
it's oddly enough, it's a condition of the wetlands approval that the easement of access be recorded on the land record. So
Yeah.
obviously, we would do it anyway.
Well, no,
Yes.
it makes sense to me. I guess the reason that I'm asking is because we had, interestingly, you know, we eliminated the, or not eliminated, we amended the regulations for subdivisions to provide for frontage, a larger area of frontage, so that we wouldn't have backlots, which would eliminate shared driveways and the like. Here, we have a shared driveway, but you still have the frontage.
Exactly.
Because of the sight line issue.
Yep.
Yeah. So, okay.
One
other
thing I would
questions about
note, Mr. Chairman, is that my understanding is that Laura Pulley, and I couldn't find the email, approved the stopping site distance, the 156 feet, which she thought was appropriate for an existing driveway, and
Okay.
in this instance, this proposal satisfies it fully.
I appreciate the representation. If you find that, Mr. Went, you can circulate that. That would be great.
So for me to conclude, Mr. Chairman, the case of Garrison versus Planning Board of the City of Stamford, 66 Connecticut Appellate 317, 2001, further states at the outset, we note the commission acted in its administrative capacity. As such, it has no discretion or choice but to approve a subdivision if it conforms to the regulation adopted for its guidance, end quote. An inland wetland application, as Mr. Paterla pointed out, was filed with the Conservation Commission and was approved. As you also heard from Michael, the proposed drainage plan has been reviewed and approved by the Town Engineering Department. Property is served by public sewer Sanitary sewer, public water, and utilities. I don't think there are any other outstanding issues. I think the application conforms to the relevant regulations. For that reason, I'd request it be approved. Members of the family of the late Georgia Bory are here with me, and they and I and Mike Paterla would be happy to answer any questions the commission may have.
Thank you. Anybody have any questions? You need to use the mic.
Is the existing house staying on the site?
Our intent is that it stay as is.
Does the applicant own the lot behind
Yes,
his two lots?
yes.
Is there any plan to develop that lot?
That lot is accessed by High Meadow to the west, and is it for sale? No, it's on the market. It's not on the market. No plans at the moment. That is a single lot. That's a different zone. That's not Residence A. So that cannot be, by my representation, subdivided. It's accessed, but again, it's accessed by a different street.
Commissioner Gordon?
What is the reason of splitting the land? Just to, they're gonna sell, to sell
Of subdividing this property?
and then sell it or build on it
Right,
or
so
whatever they
they're creating a second
right.
buildable lot.
Okay.
Okay. Any other questions? Okay, thank you, Mr. Patel.
Thank you.
Any member of the public wish to be heard on this? No? Very good, I'll close the public hearing on this item. Next, 391, 397 Commerce Drive, special permit and coastal site plan application of 391 Commerce Drive LLC pertaining to the demolition of an existing dwelling and proposed addition to an existing restaurant in the design industrial district.
Chairman, members of the commission, my name is Raymond Rizzio. Really happy to be before you tonight representing 391 Commerce Drive LLC. Folks, this is the Little Goose, as you all probably know, formerly Tucker's. This has been a mainstay, real stalwart, an anchor in the Commerce Drive area, one that's hopefully going to thrive with all the improvements that you've continued to create and the development along Commerce Drive. Little Goose has been there forever. It's not, well, just a number of years as a Little Goose, but this property's been here forever as a restaurant. It's pre-existing non-conforming. It's in a design industrial district. The property currently contains a one-story building with the restaurant, a two-family home, and a small office and storage area in the rear. The property is hindered by, it has parking. However, our driveway is a very difficult entryway. It's very difficult to know if there's any parking spaces ever there. And sometimes you drive by it not knowing whether it services the restaurant, services the two-family, services the building in the rear. We also have an issue where our entry area encroaches onto the state property. All this has been there, all pre-existing non-conforming. Clients would like to upgrade the property, and I think they're going to do it in a way that will eliminate non-conformities. It will upgrade the service. It'll help the safety of the area, help the access, help the parking, help the consistency. This is kind of one of those true addition by subtraction. So what we plan on doing is this two-family here. Let me preface this by this two-family is going to come down, and we're going to change the direction of the drive to give much better sight lines, to give a proper width because you currently can't get two cars back and forth between the two buildings. Tear down the two-family, put a modest addition to add a real waiting area, a little bit more patron area, and basically have a much better working kitchen. If you look at the pictures that I'll show you there in the kitchen, we have a prep area, and I think it's smaller than this big. But we're going to have, the restaurant's been very successful, the restaurant's, and we're going to upgrade the exterior. Steve Keatle, our architect, will take you through some of the architecture. We've previously been to the ZBA because we're required to have 9. We're basically have our parking, we have 10 spaces. With the extra patronage area, we would need an additional 4 spaces than what we have. Keep in mind, even that's with taking out the 2-family. So the 2-family would require 4 spaces. We basically went to the ZBA and got a waiver to get the additional parking spaces that were required. And the thinking being, this, once again, addition by subtraction. The problem with the restaurant and the 2-family is they both typically have their parking at night. So you had basically, where you a lot of times have compatible alternate uses. This is kind of incompatible because you didn't have enough parking and they both demanded the parking at the same time. So in this instance, by getting rid of this, first of all, pre-existing non-conforming 2-family, which is not a permitted use in a design industrial zone, we're eliminating that non-conformity. And what we're doing is allowing the building to breathe, we're allowing proper access, and we're adding additional space up to 10 space, which will now be up to 10 spaces on site. Mostly, exclusively really to service the restaurant. We're adding an additional 348 square feet of patron area, and we're adding a real addition. If you frequented the restaurant, I don't know, mostly everybody who's lived in Fairfield any time, if you have to wait for a table, wait for a drink, you got to be careful. If you bend over, you're going to hit somebody in the head with your rear end. I mean, there's no space in there. The other beautiful ability of this, and I'll take you through the floor plans, is that we're going to get to add the handicap bathroom, which we currently don't have. We have the same issue. Let me get that. Sorry. So this is our existing, as you can see, very small bathroom area. This is our entry area, which will go away. And what we'll do is be able to expand the kitchen, expand the patron area. We'll take you through the architecturals on that, and have a real waiting area. As I said, we're expanding the patron area 348 feet, but it gives us an actual prep area to prep. It gives us a better working kitchen, gives a much better walk-in refrigerator. And really, because of the way, as you can see, the addition works, it doesn't really cost us any parking because we're taking it a long and narrow approach that fits in, which gives us a conforming driveway and doesn't basically eliminate, we couldn't create any more parking spaces there anyway. So it's the best use of the property. What I'd like to do is, if you take a look at the pictures, it's important to understand it in its context. We have the post office directly next door to us.
Attorney Richard?
Yep.
Do you have more copies of these?
Sure. Do you not have enough?
No.
Yeah, I don't have that either.
I don't have that, neither does Attorney Noonan. Yeah, that one there. I need one. And then you don't have the big architecture?
No,
Do you have another architectural plan?
that looks like you're duplicated.
I think you'll be,
I have it. It's got a huge paper copy.
Okay. Basically understanding the context
Yeah, so
of
this
the
is
property.
big one. Yeah, this is in this.
So you can see there's the 2-family next to the post office. The 2-family is going to come down. You can't really even see the driveway if you're coming basically east to west. And then on the other side of us is the Audi dealer. And across the street, I believe, is going to be a new car dealer, but the building's been torn down. One of the nice things is we also have a tremendous amount of on-street parking when our needs need to be met. Most of the car dealerships close around 6. They're not open on Sunday, and there's permitted parking along Commerce Drive. This is the 2-family that's going to be coming down. This is the current streetscape, if you can see. Basically, entryway sits out on the state right-of-way, and we will clean up the front, which you'll see. I'll have Steve take you through the architecture. This is our limited driveway, which basically can fit one car. You don't even know if you're driving by if there's any parking spaces there. And what happens a lot of times, since people can't see, even if they do pull in and figure out their parking's there, they don't, and it's not until they get to the rear that they can even figure out if there's a spot available. And God forbid there's somebody else with the same idea. It's a shake back and forth. This is the rear of the house, which will come down, which will now be replaced by the driveway. And the nice thing is the building will continue to also shade the parking from the street. So this is the rear of our property. We have our little herb garden in the back so that you get fresh herbs when you're served, tomatoes, all different things that we cook out there. And then what I wanted to show you was the entryway. If you'll see pictures of the entryway. That entryway is going to be removed. That entryway, which is basically if you open the door, you can't stand in there. More than one person, the only way to stand in there would be to keep the door open, which doesn't work really well. And I think we've heard enough about corridors tonight, but this one we don't need. Okay?
Had to go there, didn't you?
So we're getting rid of that. This is the current bar, and I wanted to show you what the kitchen is. And the kitchen is, as you can see, very small, needs to be increased, and it's been just a very difficult work area. So what we're taking this old, got to be 60-year-old restaurant building and turning it into a restaurant, which really doesn't create a lot more people, but makes it the ability to work a lot more efficiently. What I'll do is I can take you through, and Steve's here to answer any questions if you want to look at the outside. If you've had a chance to look through this small handout, you'll see just a considerable, basically, reworking of the building, an upgrade, architecturally nice, very pleasing from the street, the ability to interact with the street in the front without having that as basically your only waiting area. The building out the side, this will be able to be basically open during the warm weather, and it's going to be a full year-round use that will be contained, but the windows will be able to open and the doors will be able to open, and you can have the ability of almost having an outside dining experience in the warm weather. As you can see from the front, colors are nice, very colonial looking, basically a real upgrade along the industrial looking Commerce Drive. This is a better look from the side, and this is what you'll see. And the nice thing about it, and it's funny, I always understand it's nice when you can open and people can get the feeling of dining outside. But what's nice about here is by cleaning up the site, we're not going to be sitting out on Commerce Drive, with used cars going by and everything else. We're going to basically be able to contain it, enjoy the fresh air, be able to use it year-round, yet basically be a very comfortable seating area. Steve, if you want to just come up and take them through some of the elements of the architecture. I think the rest is pretty straightforward. Where, like I said, I think we have a tremendous improvement to the site.
Good evening. My name is Steve Keatle. I'm an architect with Keatle and Lee Architects in Trumbull, Connecticut. As you can see from the rendering that hopefully you all have, what we were trying to do is create sort of a pub front. It's 12 feet by 12 feet. That's where the new entrance will be, the new waiting area. The existing entry will be removed, and we'll have a small fireplace, gas fireplace, and it takes the form of a stucco chimney on the front there. And then as you go around the side of the building, we have a room for sort of semi-outdoor dining. There's going to be more like a garden room. And we're trying to combine sort of a New England bistro with an English pub, and that 12-foot by 12-foot kind of harkens back to a pub you might find in England. Any questions?
Any questions for us? No? Very good. Thank you.
Thank you.
The risk of being described as brief, I will basically state that we believe this application satisfies all your special permit standards. It increases the safety on the site. It increases the interior traffic flow on the site. It basically it opens it up for proper site distances and site clearance from in and through the street. It eliminates a pre-existing non-conforming use from the site.
and we believe makes the parking, actually more parking available than is currently existing on the site. We think all in all, this is an excellent application that has no negative effect on any neighboring properties. It has no detrimental effect on any property values, and we think it'll continue to be a great amenity for the neighborhood that this commission has created over the last few years along Commerce Drive, and very consistent with the overall overlay zone of Commerce Drive. I'd be happy to answer any questions. Yes.
Mr. Corcoran.
The building that's at the back of the lot,
Yes.
it's quite a large percentage of the size of the restaurant building. What's going to be in there?
That building's always just been used as a small office over the years it's been rented out. Now it's been used as an office for the little pub, where they basically do their books, things like that, and storage.
I mean, okay.
The building in the back.
Yeah, the building back.
Yeah.
There's space in the upstairs
Yes.
for that. That was offices once.
Yes.
And there was a Reiki studio in there, but,
It's always been just minor office and storage, and that's what will remain.
so does the parking consider that space?
What happens is when you take the parking in these non-conforming properties, for example, you have to look at what's currently there, what's being replaced, and how does that affect the overall. So everything that's there is grandfathered. The additional square footage for the patron area, I think, would require 9 additional spaces. We are getting 1 additional space, so we're going from 9 to 10 spaces, so that's 1 of the 9. We then also get credit for getting rid of the 2-family, which is 4 spaces. And then we have a waiver from the ZBA for the additional 4 spaces. So that's how we get all the parking to work.
So
Does that make sense?
Yeah.
Okay.
So on this map that I have,
Yes.
the,
Which one are you on? So we're talking the same thing. Okay.
so the parking spaces don't go up to the fence anymore, but there are lines drawn there. I don't quite understand what's going on.
What happens is the parking is going to be, you mean here?
Yeah.
Yeah, the parking was just a mishmash, just an overlay. When they redo the parking, they managed to establish a buffer here, and then also create a buffer up the side, and eliminate some of the impervious that's currently there. That make any
Okay.
sense?
Yeah, I mean, I see, the dotted lines are where the spaces used to be.
Yeah,
Okay.
yeah.
Okay.
So it's just kind of, the way they overlay it, you have to look over for example, you still see kind of where the house was.
Yep.
As relates to the driveway.
Okay. Any other questions? All right. Thank you very much, Attorney.
You're welcome.
Any member of the public wish to be heard on this? All right, hearing none, I'll close the hearing, and I'll adjourn the meeting.